Hello, one and all. I welcome you all to the MOOCs program on Advanced Constitutional Law. I am Dr. Neelam Batra, Assistant Professor, Punjab University Regional Centre, Ludhiana. Today, I'll be discussing the topic of scheduled and tribal areas. For the sake of convenience, I have divided this topic into different parts, that is, historical background, important features of 5th schedule and important features of 6th schedule. The learning outcomes of this topic are to study and analyze the constitutional provisions contemplated for providing special significance and importance to the areas inhabited by the aboriginals who are considered to be socially and economically backward. Another learning outcome is to study the constitution and functions of special councils, boards, as well as the other institutional mechanisms in order to improve the standard of living of these people. Another outcome is to study various ways and means adopted in order to preserve the cultural uniqueness of these people. The protection of the cultural uniqueness is the motivational force behind the provisions of 5th and 6th schedule. The main purpose of 5th and 6th schedule is to provide security to these people. The interest of the scheduled areas and scheduled tribes in the states other than states of Assam, Meghalaya, Tripura and Manipur, they are protected by the provisions of 5th schedule. The interest of the tribal areas in the state of Assam, Meghalaya, Tripura and Manipur, they are protected by the provisions of 6th schedule. Now coming to the historical background. Tribals were the earlier settlers in India. They were slowly pushed back to the forest and the hilly areas by the succeeding settlers who were non-tribals. Now these forest and the hill areas, they have completely isolated these people from the rest of the country. So these people established their own civilization and were governed by their customary or primitive laws. From medieval to the modern times, the successive governments who ruled India, they also allowed these people to survive in absolute remoteness and were permitted to be governed by the special laws. The Scheduled District Act 1874 was considered to be the initial measure whereby these areas were considered as a class in itself. Now this act facilitated the executive to extend any enactment in force in India to these areas with such modifications as required. Now a brief reference of these areas was found in the Montagu-Chelmsford Report of 1918. It was acknowledged in this report that the political reforms considered for the whole of the country could not be applicable to these areas, that is the tribals as well as the scheduled areas. So, under the Government of India Act 1915, these areas were divided into two categories. The central legislature as well as the provincial legislature had no authority to frame laws for these areas. The governor was given the whole power to make laws for these areas. Even the ministers were kept out of the responsibility of making laws. Whatever proposals of expenditures were there, they were not required to be voted in the Legislative Assembly. Even without the sanction of the governor, no matter could be raised in the State Legislative Assembly. As per the Simon Commission, uninterrupted separation of these areas from the chief current of development would not be a workable solution. So, the centre should be given the responsibility to administer these areas. along with the center, the provinces of which these areas form a part should also not be alienated from these areas. However, these proposals were not accepted in the constitutional reforms of 1935. Under the Government of India Act 1935, the executive was vested with large powers. These areas were divided into two categories under these Act under Section 91 as well as Section 92. Now, these two categories are excluded areas and the partially excluded areas. The excluded areas are administered by the governor. The full responsibility is of the governor, while the partially excluded areas, they are under the ministerial responsibility. However, the governor was given an exceptional power to overrule the ministers if required. Now, a reference of these areas was also made in the Cabinet Mission Statement of 16th May 1946. In terms of paragraph 20 of this statement, an advisory committee was constituted by the Constituent Assembly on minorities, on children, as well as the excluded and partially excluded areas. Now, the advisory committee was required by the Constituent Assembly to form 3 subcommittees in order to prepare the scheme as well as to report on the schemes for the administration of these areas. Now, 3 subcommittees were constituted by the advisory committee, and these 3 subcommittees are: number 1, the Committee on North-East Frontier, on tribal and excluded areas. The second committee was on excluded as well as the partially excluded areas other than the state of Assam. The third committee was the Committee on Northwest Frontier, Province and Baluchistan. The first subcommittee submitted its report in the month of July 1947. The second subcommittee submitted its interim report in the month of August 1946. Even a joint meeting of both the subcommittee was held where the recommendations were laid down before the Constituent Assembly. However, the third subcommittee was not called upon because it became the part of the Dominion of Pakistan. Now, in order to give effect to the report of the subcommittee, 2 articles were included in the draft constitution by the drafting committee on the recommendations of the advisory committee. Those 2 articles were Article 189 as well as Article 190. Article 189 defines scheduled areas and tribal areas, whereas Article 190 is similar to that of Article 244 in the Constitution, which we will be discussing later on. As the process of integration of states was moving very fast, so the drafting committee reconsidered these provisions again. Even Dr. Ambedkar suggested the deletion of these 2 articles from the Constitution. And finally, at the revision stage, these articles were removed from the Constitution and Article 244 was brought into force. This was all about the historical background on the governance of scheduled areas and scheduled tribes.